mention.
This method may some of them create, but this is called long-term and the area salary. The case is held from 1 year back. Till today, no FDP, nothing has been done.
It hasn't come for motion also.
No, motion, it will come for admission now. How's that right?
Not in this week. Not in this week. Monday 18th.
Monday?
18th. 1/8.
Yes. May be at 2 p.m. 2 p.m.
Monday.
Monday.
Item number 32, my lord. I am for the respondent, my lord. And here, my lord, we have to produce the service record of the respondent, my lord. And he will pay for the petition also, my lord. Maybe adjourned for today, my lord. Record has not come, my lord. Maybe after Puja vacation, my lord.
Give us a date.
2nd of November, can it be?
No, it is Bondo.
2nd of November is a holiday.
Holiday.
You can have it on 7th or 9th.
9, my lord.
9th.
Yes, Mr. Deka. 9th.
9th.
As agreed by the Learned Council 40%. On the prayer of the Learned Council. List on 9, 10, 2020. 9, 10,
9, 11.
9, 11 for hearing.
Mentioning for listing, matter was notice was issued on 22/6/2024, returnable by 4. Matter pertains to the dismissal, and petitioner submitted a department appeal, and there is a observation is while issuing notice, there is a observation that pendency shall not be barred to consider matter, but till date not considered. So matter will be listed next to any date matter.
28th 20.
Lordship 20, I have some.
22nd.
May I please, your lordship, my lord, I have a prayer for listing of a case, my lord. This is a transfer matter. The headmaster of a concerned school, he has been transferred, my lord. Lordship will kindly be with me, my lord.
Headmaster of the school is transferred by whom?
By the district elementary officer, my lord, on the basis of wrong allegations, my lord, and false allegations and false observations also, my lord. I have an next, my lord.
When the order was passed?
The order was passed, my lord, on 5th of this month, my lord. And I have been, my lord, served with another order, my lord, to hand over the charge to the assistant teacher of the school, my lord, day after tomorrow, my lord. Therefore, my lord, I have a prayer for listing of the case by tomorrow, my lord.
When did you file?
I filed on yesterday, my lord.
You have the filing number?
Yes, my lord. I love it.
I would like to mention one writ petition for listing under admission column regarding non-payment of family pension to the deceased wife. It was listed on 14 August, but did not reach her.
Okay, on 14th, 1/4.
1/4.
Lordship, I beg to mention item number 33, your lordship. I have taken consent from the petition, your lordship. I am for the respondent there, lordship. Lordship, what happens, lordship, in the last 33.
Yes. This matter, my lord, yesterday he rang me up, my lord, regarding my lord. Date may be fixed.
Kindly switch on the microphone.
It's on, your lordship.
Yes.
My lord, date may be fixed, my lord.
Give us a date. Decide among yourself and tell us a date.
What's in the month of October, your lordship?
Give us a date.
On my lord, 3rd October, my lord.
5th.
5th October, lordship. Much obliged.
The priority council.
Withdraw item 28, lordship.
You want to withdraw item 28.
Yes.
Let us finish the mention movers. Immediately you will take up item 28. Don't go away.
Okay.
Yes.
May I please, lordship? I beg to mention item number 21, lordship. It ought to have listed under order stay vacation, but it is listed on orders, and also we have, I am for the petitioner, we have filed a reply in the
21.
29, lordship.
Yes.
So it may pass out for the day, any other date, lordship, is convenient. And affidavit is also not on record that we have filed to the IA. We have taken consent from the other side.
When do you want?
Any convenient date of this honor.
Other side is agreeable.
Agreeable to the adjournment, lord. They have prayed, requested me to pray for next week Thursday, lord. If that is convenient.
Okay, on the priority council for list on 21st. Yes.
Lordship, I beg to on listing one writ petition in admission column, last posted on 14/8/2023, and it was fixed on 7th of September, but it was not listed. Fixed matter. Can it be Lordship on 14?
Not in this week. 26th. Yes.
May it please your Lordship. I beg to mention item number 23, Lordship.
Hmm.
May it be passed over for the day, Lordship. Hezbollah is not keeping well, Lordship.
Counsel for the petitioner. Representative for the
Lordship, I would like to mention a matter for listing a Lordship. Lordship, matter pertains to pension, and it was last listed on 14/3/2023. Notice was issued. After that, it was never released. My lord, for orders. Next week, my lord.
22nd.
Oblige your lord.
Maybe in item number 21, there is an interim order. I did not pay for the extension.
Oblige.
Listing of a writ petition, Lordship.
Which one?
Pending matter.
You want to
Listing.
withdraw, right?
No, Lordship, I'm listing. This is another matter, Lordship. Compassionate family pension matter. Any day next
It will
week,
come for what?
admission, Lordship. Next week, any day.
Let us see. Okay, on 28, 20. 8/28. What's your good name?
NZ Chaudhary, Lordship.
You're appearing for whom?
Mr. A.R. Priya, Lordship.
Mr. Learned Counsel, appearing on behalf of Mr. A.R. Counsel.
What has happened, Lordship, actually petitioner's prayer is on the process of being addressed at the governmental level. So, Lordship may kindly give liberty if at any time need arises to file it.
Please for retirement. Reverse to file this as an unfaced for the petitioner. Prayer allowed. Petition is dismissed. Being not fixed. Liberty has been. As the connected application number 264 of 2021. That was referred by the present applicant. Not fixed. This interrogative application. Again,
This is a matter with regard to transfer on the basis of safety and security of a teacher. There's a act under which it has been
what is
done.
the transfer order?
No, that's the transfer is actually I sought transfer. I was initially given transfer. That order your lordship will find at page 37. This is the initial transfer order. I applied for transfer on the basis of safety and security. I was given the transfer order that is at page 37. My name is Sudarshana Batsa. First one, I have been transferred from Tadong High School to Bezera High School, Kamrup. I sought the transfer because I was having a small child, a baby, for taking care, and there was a safety and security in the area where the school is, earlier school is located, and I was transferred on the basis of your lordship, the letter that your lordship will find at page 36. Page 36 is a letter of the Deputy Commissioner. So the ground that I have sought was felt correct, and therefore I have been transferred on the safety and security ground. So on the basis of that, I was transferred. Then, Your Lordship, I was not allowed to join. I came before this honorable court by filing a writ petition. In fact, there were two writ petitions filed by both the petitioners, both the persons who were transferred, 1 and 2 of the order dated 21/1/23. And the writ petition, Your Lordship, will find at page 39. These two writ petitions were taken up together. And by the order dated 13/2/2023, the court said that the order of transfer was not correct, not technically correct, on the ground that one issue was not taken care of. That is, the authority, approval authority was not consulted. Therefore, there was a direction that Your Lordship will find at page 51. Para 18, Your Lordship, of the judgment. Last penultimate paragraph. I'll just have to read this paragraph, Your Lordship. Taking into account the application so made both under the manual mode as well as on the online mode by the petitioner number so and so, and further taking into consideration that ground exists for transfer in terms of Rule 9, as has been certified by the Additional Deputy Commissioner, Borpeta District, in its certificate dated so and so. This court directs the Deputy Commissioner of Borpeta District to verify as to whether any of the ground mentioned in Section 9 still exists, and in the case of the petitioner so and so, and if so exists, refer the same to the competent authority under Section 5(2) of the Act of 2020, and the competent authority thereupon is further directed upon such reference being made by the Deputy Commissioner to consider the proposal of the petitioner. In the eventuality the competent authority deems fit, the state competent authority recommend to the appointing authority for issuance of the transfer order. The appointing authority, upon being satisfied with the recommendation, shall pass appropriate order for transfer. The said exercise may be carried out in terms of Section 9 of so and so Act, Rule 11, Rule of the Rules of 2022, as expeditiously possible, not later than 45 days from the date of certified copy of the order. Now, Your Lordship, they have then I have filed my application. After my application, Your Lordship, at page 56 is the order again by the Additional Deputy Commissioner. There were some issues with regard to uploading of the documents in the website, because this is done through the website. Here, Your Lordship will find at page 56, submission of certified copy of safety security certificate issued to Sudarshana Vatsa. With reference to the subject cited above, I have the honor to furnish here with the certified copy of safety security certificate issued to so and so, signed by the Additional Deputy Commissioner Borpeta with approval of the Deputy Commissioner Borpeta. It is also mentioned that the user access for the Deputy Commissioner option so and so in the AHRMS portal is still not provided by the government yet, so that the Deputy Commissioner or the DC exigency user may not be able to upload the safety and security certificate issued to so and so to the competent authority through the HRMS portal. The matter may be treated as Guwahati High Court urgent. After this, Your Lordship, I made an application again to the mission director, who is the appointing authority, and thereafter, Your Lordship, again a legal notice was issued. I am not reading this. Then ultimately, Your Lordship, again at page 62.
Yes.
With reference to the subject cited above, I have the honor to inform you that the safety and security certificate which was issued by so and so vocational, which is to so and so vocational teacher of so and so, has been uploaded from the Deputy Commissioner portal. So that has been uploaded. Now thereafter, Your Lordship will see it, the impugn order that is at page 63. This is by the mission director. Your online application submitted and so seeking transfer to a school of your home district, Kamrup Metropolitan or Kamrup District, in the same service category on various grounds. Inter alia, the ground of safety and security of female teachers has been duly processed in terms of the Honorable High Court's order dated so and so. As per the statutory provisions, the transfer order to a vacant post in the suitable district and school shall be issued. However, on verification, it is found that no vacancy is available against vocational teacher post in Kamrup Metropolitan or Kamrup district in the same category as paid for. And there are 2 numbers of vacant posts in Bokel High School, Dibrugarh district, and Borthal Doloigaon High School, Morigaon district. In view of your request to give your preference and consent to join one of the aforesaid school for enabling the undersigned. Now, your lordship, I have come under safety and security to be transferred to one of the 2 districts of Kamrup. And they have done it initially by order at page 37, your lordship. This particular school, your lordship, what they have done, Sudarshana Bachchan, Abu Sufyan Siddiq, these persons were interchanged. Your lordship will see the schools. Kadong High School to Borpeta to Bezera High School, Kamrup. And the Abu Sufyan was Bezera High School, Kamrup to Kadong High School, Borpeta. And both these petition persons have filed an application for transfer.
What happened to that Abu Sufyan Siddiq? Where is he now?
He is in the earlier school. I am also in the earlier. We have sought transfer. That transfer order was not implemented. Court directed us. Now, why they are putting us in Dibrugarh, your lordship?
Yes, madam.
The finding of the authority is that there is no vacancy.
Yes, madam.
Now, at page 37,
Yes.
it is clear that both the teachers are.
There was a mutual transfer earlier.
So, pursuant to the order of the, not only the case of the petitioner, but also the case of the other person, Abu Sufyan.
He was
should have
also a
been
writ
considered.
petitioner.
Because he was also one of the.
Yes, madam.
We have seen that order annexed. But what we have seen here is that only the case of the petitioner has been taken into consideration.
Yes, madam.
And that's why if the petitioner's case is alone taken up for consideration, there will be no vacancy.
Yes, madam.
Because that Abu Sufyan Siddiqui, who was earlier considered for DPL transfer from Kamrup to Borpeta district, will remain in Kamrup district. So even the petitioner is discharged from Borpeta, she will not be able to place anywhere in Kamrup unless this man is allotted to Borpeta.
Yes, madam.
The decision should be taken by the authority concerned, considering both the, keeping in mind the decision of the order passed earlier by the, right?
Yes, madam.
So what to do?
Only thing, madam, the order was issued by the impugn order issued by the mission director SSA, madam.
True.
Name has not been shown,
Now,
madam.
both the parties are both the teachers are serving under RMSA or
It seems to be, madam, under RMSA. It's a vocational
Teacher.
teacher, madam.
under RMSA on
Yes, madam.
appointment we have seen it is under RMSA.
Yes, madam. Because in page 37, madam,
Hmm.
the subject is retail trade.
That's right. Go on.
Name of the
No, copies have not been served. That we have.
SSA.
party respondent, I think two mile here.
SSA copy diya na.
In fact, Mr. Mannan,
Yes.
you haven't also made come to page number 39. That is your writ petition.
That is my writ petition.
See whom you have made parties 5 and 6. 5,
Yes, 5 was,
5, 6, 7.
yes.
It have been also a party here. So I think you better withdraw and file a petition. Keeping deputy. Also deputy commissioner.
Deputy commissioner is made a party.
Only Borpeta. Not Ravi.
No, because it is.
We understood.
Yes,
The thing
what
is, it's an earlier round of litigation.
Yes.
Day-by-day party.
Yes.
Court considered it.
Yes.
To pass that on. Now, any order to be passed, unless you make them a party, to consider the case with the other person was initially been transferred because there's a mistake.
Then your lordship may allow me to make
Well, fresh, doesn't
that Abu Sufyan as party.
And I think you have to, in that case, you have to also make a party 5, 6, and 7 because you want to come to Bezera.
Yes, but Bezera, actually what I'm trying to say is that it is the authority who will give the order.
See, unless this man, Abu Sufyan Siddiqui, is transferred out of the present school where he is serving, there will be no other post, vocational post available in the district of Kamrup. Other posts available, it has been pointed out. So if you want to transfer, you can be posted in all those districts, not in the district which you are seeking.
Yes, the Dibrugarh district is there.
Think over and do.
No, if your lordship,
I think that that will help you. Otherwise,
allow me to include these.
or otherwise you have to file an implement application for all these persons incorporating party. It's up to you.
No, if your lordship allows, I can implement these 3 persons.
Allow me to file your application.
For
File
implement.
application.
Lordship may just.
Up to you. So you want
I'll implement it.
probably these 3, 4 persons are
Because I think Abu Sufyan part is, your lordship is correct.
and then the school from which he'll go.
Yes.
Because the principal might object that
Yes.
if you're taking somebody and not appointing somebody, my student will suffer, right? So naturally, once the principal comes in, the inspector of schools comes in. Again, it's a RMA post or the deputy commissioner comes in. So they are needed that way.
Yeah.
So up to you.
No,
I leave
that
it to
is,
you.
your lordship is correct. I'm not on that. I'll implement that.
Okay. File your application at the earliest.
Yes, I'll do it.
Heard Mr. O.S. Manan, counsel appearing for the petitioner, and Mr. Near study counsel department of school education. On instruction of the petitioner, Mr. Manan Lana, counsel. Seeking time to file appropriate implement application for implement of necessary parties to present proceeding inadvertently not yet. Prayer allowed. If you make a mention after filing implement.
Lots. What's up?
Obliged.
Before Milord takes up this next matter, item 28, Milord, there is an order for making an inquiry by the UGC.
That what we have seen, that the fixed certificate of that particular.
Yes, Milord, that cannot be allowed to conclude, Milord. That should not be allowed to withdraw. We did not give our consent, Milord. Since there is a apprehension that it
That
may
we
come
have
out
seen.
fake,
That's a fixed certificate needs to be inquired by the UGC.
my lord, there is an order by this court.
We'll modify that order. We'll inquire and submit the report before the court. We'll not look into it. It is a fake.
Right.
Submit it. We'll allow us modify to that order since already there is an order.
My lord. In today's order, Lordship will mention it.
Definitely. Definitely. We'll just modify that order.
My lord.
The inquiry was directed to be done by the UGC.
My lord.
But
This will that will continue.
That will, but you have to do it within time.
My lord, we'll fix a date, my lord.
Give us a date. Give us a date.
31st of October. Or not before 31st of October.
Before the submitted before the.
Yes, we will submit before
Commissioner
the
Secretary Higher Education.
Higher Education. Government of Assam. Yes.
Along with a copy to the Director of Secondary Education.
My lord.
And the petitioner as well.
My lord.
This three
If
persons.
necessary, Lordship allows, my lord, we'll file an affidavit here also.
Doesn't matter. It's
So
a
we
close separate-
to kept in record.
Informing the Registrar General of the Guwahati High Court.
Yes, yes.
That will do,
That will do.
right?
My lord.
So that will be incorporated in the
My lord.
main record. Then you submit it before the Commissioner.
No, it is apparent that they are
Copy to Director of Higher Education Assam and the petitioner as well as the Registrar General.
as a Lordship mentioned in the order, we will follow it. But 31st October, my lord, because
That's why we are seeking. Give us the date. You said 31st of October. Just a minute. Okay, fine.
my lord, obliged. Lordship will record our presence.
Yes. We have seen that that direction was given.
Yes, ma'am.
But the petitioner's counsel said, of course, he was appearing someone for Mr. Ayer Bhuiyan.
My lord, since Lordship has dictated that order, perhaps earlier secretary. Probably. Probably. We'll look into it.
My lord.
We'll modify that. 2 minutes. That's not correction. Correct. Yes. Mr. Das.
Yes, my lord.
You have to explain something to us.
My lord, this office memorandum doesn't say anything about this office memorandum doesn't say anything about pension scheme and all, my lord, other benefits. the office memorandum annexed by the petitioner by way of additional affidavit.
Lordship may peruse the appointment letter. It clearly says that the tutors are to be governed by the NPS scheme, and they shall be treated as a state government employee.
Take your seats. Yes, Mr. Mazumdar, tell us how you are entitled for such benefit.
Lordship,
First, read the definition to you. Read to you.
tutor means and include teachers, assistant teachers, classical teachers, and also includes lecturer, assistant professors, associate professors, principal, vice principal, demonstrator, headmaster, assistant headmaster, superintendent, assistant superintendent in a provincialized educational institution under this act who are not eligible for provincialization of their services and whose services cannot be provincialized in the post of teacher under this act due to lack of her educational and professional qualifications required as per the Right of Children to Free and Compulsory Education Act 2009. And the relevant
Yes, please proceed.
And the relevant rules and regulations framed thereunder and any other act as the case may be, as applicable on the date of provincialization, however, his or her service is provincialized as a tutor with separate terms and condition of service to be notified by the competent administrative department. Whatever I have understood.
Please proceed further.
Provided that a tutor shall not be eligible to hold the post of professor, principal, vice principal, headmaster, assistant headmaster, superintendent, assistant superintendent, as the case may be in an educational institution provincialized under this act. The next is B, university. It is next part is
please come to section 8.
Terms and condition of services. Section 8, subsection 3 is about for tutors.
Read 1, 2.
Yes. Subject to the provision of this act and rules made hereunder, all rules including service rules and rules of conduct and discipline which are applicable to the state government servant of corresponding ranks shall be applicable to all teachers of educational institutions whose services have been or to be provincialized under the provision of this act. The teachers whose services have been provincialized under this act shall get full scale of pay and such emoluments as salary and allowances as per norms of the state government applicable to the employees of the correspondent rank with effect from the date of provincialization of their services, as if they are fresh appointee and they cannot claim any benefit whatsoever in respect of the past services rendered by them before provincialization, and in respect of pension they shall be governed by the new pension scheme applicable to the state government teachers of the corresponding rank. That part, this 3. For the tutors whose services are provincialized as tutors under this act, their scope of work and other condition of services shall be notified by the concerned administrative department separately. The emoluments for the tutors shall be paid at the rate as specified in the schedule appended to this act, subject to the condition that enhanced emoluments after 2 years as per the schedule shall be admissible in respect of a tutor on submission of a satisfactory performance report by the head of the concerned educational institution to the drawing and disbursing officer after completion of 2 years service from the date of provincialization. In the event of subsequent acquirement of educational and professional qualification by such tutors within 5 years from the date of provincialization of the services of the teachers in the concerned venture educational institution, they shall be eligible for upgrading their post as the teachers. In the event of failure in acquiring the required qualification within 5 years from the date of provincialization of the venture educational institutions, he shall continue as a tutor only under the terms and condition of service, including their salary and allowances, as may be notified by the government under the subsection 4 of this section. The scope of work and other terms and conditions of service of tutors shall be notified by the respective administrative department separately. The teachers who have completed 60 years of age on the date of coming into the force of this act shall be deemed to have been retired with effect from the date, and they shall have no claim whatsoever from the state government as regards their pay, allowances, retirement, benefits of service already rendered by them in such educational institutions before the date of provincialization. The teachers and tutors provincialized under this act shall hold personal posts to be created for provincialization of their services. This post shall be outside the cadre, which shall stand abolished on cessation of services by the concerned teacher or tutor, as the case may be, due to retirement, death, resignation, or any other reason whatsoever.
So, tutor services are not provincialized, as in the case of teachers. The tutors are placed in a different place, not as a general teacher, because the tutors cannot be provincialized. The services of such tutors cannot be provincialized
as a teacher.
And their terms and conditions will be guided by the separate
notification or office memorandum.
You have read section 8 and you have seen for whom the pensionary benefits have been given and why the pensionary benefit haven't been given to the tutors. Because service of the tutors are not provincialized as such. But yes, if the tutors within the specific period of 5 years from the date of such kind of their provincialized of services, if they can obtain such higher education or the required education, they will be upgraded. Once it's upgraded to a post of teacher, things will change. And that is why section 8 clarifies the pension benefit given to teachers. And while preparing the act, the formulators, the preparators have found that the pensionary benefit is not given to the tutors. Only when acquiring their expected degrees or the qualification, on their upgradation to the teachers, they will be eligible for pension.
Lordship's explanation, I am not contradicting, it is undisputed. I am accepting that explanation. But the act says...
Now, can we direct? It is an act under which your service has been considered, and though you are not qualified, the government considered to provincialize you, not right, as tutors.
Yes.
Giving a lump sum salary,
yes,
which is to be enhanced after 2 years, subject to satisfaction of the report,
certain condition,
right?
Yes,
and giving you ample of chances, 5 years to obtain the requisite qualification. If you see the other law, who are not qualified by their whatever the education is required, they are not qualified. Government have considered all these aspects, giving you 5 years of term, giving you salary from the public exchequer to acquire that particular education. But at the same time, government did not consider to give you the benefit of pension. You're out of that scheme.
The basic issue.
Do you want to have the benefit of this 2017 Act, or you want to amendment of this 2017 Act?
If
you want to amendment of this section, then you have to go to different.
Lordship, I'm not on that point. I'm not going.
You want
to
benefit what? You want to benefit of?
No, I am just on my
You want the
appointment.
benefit of compassionate family pension. These are available to whom? These benefits are available to whom?
Regular employee of the state government.
Are you a regular employee?
But
are you a regular employee?
My service is.
Government have taken a decision. Those who have been placed in a fixed pay of salary under RMSA or SSA, certain benefits are given to them. Whether such benefits are given to the tutors, can you claim that benefit? If the act is not given to you, by filing any application under 226 of the Constitution, will you get such benefits?
I am not.
Are you challenging the act?
Lordship, I am.
Certain provisions are not available to tutors under the act. You have read. That's why we have asked you
No,
to
no,
read.
that is, I am not contradicting. Right?
Then if
That
it
part is act.
What is your prayer?
I am on my appointment.
Anything further?
Lordship,
Anything further you are to argue?
I may be allowed to read the certain provision of my appointment letter, Lordship.
We have seen that. You have been appointed as a tutors.
And it is said that they shall be governed by the NPS applicable to the state government employees.
For whom? Tutors. Let us see.
Page number 11 of my.
Yes, if it is beyond the act, that will be inapplicable. Even if there is a condition. Let us see that clause.
That I may be allowed to read the.
So which portion? Let us see. Which clause of your appointment order?
In the second paragraph. The employees whose services have been provincialized under this act shall get pay and such emoluments as per the norms of the state government or as per the provision contained in this act with effect from 1/1/2021, and they will be treated as a fresh appointee. They cannot claim any benefit whatsoever in respect of the past services rendered by them before provincialization and in respect of pension. Then, comma, they shall be governed by the NPS applicable to the state government employees of the corresponding rank.
So you want to get this benefit, right? This particular order, whether it is applicable only to you or some been considered as professors or teachers. This particular order consists of even teachers.
This particular order, my service have been provincialized as a tutor. That is why my understanding is that it is also applicable in my case.
Okay, good. Anything else?
No.
Fine. Dismissed. Order has to be followed. Next. Give it to us. Mr. Das, please don't go away. You have to tell us something.
The phlegma portion is there.
The Mahasabha is connected to the non-payment of citizen subsistence allowance.
Yes.
Moreover, Lordship, yesterday petitioner came to the office, Lordship, and he himself has confessed that he has not filed any case, Lordship. The written I have already produced, given to your Lordship.
No, actually,
In
what
his
happened,
own-
Lordship?
In his own handwriting. Moreover, I have got the audio clip also, Lordship.
Superintendent കുറച്ച് മൂന്ന് കേസ് സിംഗിൾ
Yes, Mr. Das, when he was released on bail. When he was released on bail.
Order is there only, Lordship.
Tell us from the order that you have sent. You have the copy of the writ petition.
Lordship, I have.
Page 19. Page 19. One minute.
When he was released on bail.
18.
Lordship on 18/5/2023.
18/5/2023. When the wife of the petitioner approached you, intimating you with regard to this bail order? When did the wife of the petitioner approached the authority, intimating the release of the petitioner on bail?
Lordship.
On which date?
I don't have the instruction, Lordship, right now. Right now, I don't have the instruction. (22/5), Lordship.
Now, tell us when you have had this review meeting within 3 months as required.
Lordship.
When you have placed him under suspension from the date of his arrest, right? Taking into custody. That order was issued sometimes on 12th of April 2023.
Lordship. That order.
We understood that 3 months
Lordship,
will start only from the intimation
Lordship.
from the date of his release on bail.
Lordship. Lordship.
As per your instruction, he was released on bail on 18th of May 2023, but
Lordship.
this was intimated to you by the wife of the petitioner on 22nd of May 2023.
Lordship.
Thereafter, when did you have the review committee meeting to consider to keep the petitioner under suspension?
Lordship, actually the entire exercise of suspension and the review meeting is being done by the director, Sericulture.
When?
That my friend can.
Yes, Mr.
My instruction is that review
Not done. Do the needful. Please make a copy of the instruction that you have.
Lordship.
That the wife of the petitioner approached the authority on 22nd of May.
Well,
We'll fix it on Friday, pass the appropriate order,
well,
or we'll fix it on Monday, give us the order, show us the order.
well, by Monday,
Monday. We are not on those dispute who has filed this writ petition or somebody else has filed this petition. But whatever the right the petitioner has, he should have it.
My Lordship, petitioner in fact came to
No
my
further,
home.
we are not on that. Now tell me, he is Osato Nath or Osat Nath?
Lordship,
Are you sure?
this is in Assam is Osotonat.
Osato Nath.
Osotonat. ACHATA. Osotonat.
TA.
Yes.
Are you sure?
Yes, Lordship.
How is signature? Why there is A after T?
Lordship, his handwriting is like that. It is very difficult to understand.
There is no A.
there is a discrimination name even, madam.
We are not in that discussion. Mr. Dhor,
Hello.
we are not in those disputes,
Mile,
right?
mile.
The concern is a public servant, whatever it is. List on 18, enabling Mr. R or standing counsel, Department of Standing Counsel, Sericulture, Handloom, Textile and Sericulture, to place relevant instructions in them. Pass the necessary order, reinstating him in place. Tell us about the case. What is your prayer?
The case is such that the petitioners herein, they were engaged as spindles, mate, and fallacies in the Directorate of Land Record. Now, Lordship, from their initial date of inception, they were all along being granted the regular scale of pay. Subsequently, Lordship, in the year 2013, Lordship, the regular scale of pay which was granted to them, that was their services were reduced to the status of contractual employees, and they were being paid the fixed remuneration as per the contractual agreement. Now, Lordship, in this situation, we have challenged the contract executed by the authorities, Lordship. And subsequently, Lordship, the authorities have filed an additional affidavit
Dear Lordship, Lordship, sir, can I have the another second quote? I have some quote. Obvious.
Mr. Borpuzari, in terms of the order of the division bench, the petitioners have been paid fixed pay.
Yes, my lord.
Fixed pay at what remuneration?
After the passing of order, my lord, judgment and order in Upen Das, and the finance department has issued notifications, and thereby granting the relief. Now, my lord, as on date, my lord, an amount of rupees 15,000, my lord, has been paid.
To the petitioners, not
My lord.
11,000.
My lord,
Not 11,000.
not 11,000. 15,000 is fixed, my lord. 15,000 plus other, my lord, allowances. So that will be the minimum of the pay scale.
That's right.
Yes, now,
You have 2-3 notifications in that regard.
yes, my lord. The latest one. My lord, the last notification is issued, my lord, on 3rd of October 2019. My lord, it says, my lord, the fixed wages remuneration on rupees 15,900 with dearness allowance will be admissible, which will undergo revision whenever pay scale changes based on the enhancement of DA and recommendation of pay commission, along with medical allowances of rupees 600 per month. So therefore, my lord, the basic component of the wage structure will be, my lord, rupees 15,900.
Yes, Mr. Henrik, what is your stand?
In our affidavit, we already been stated, my lord, that they have given the, my lord, that minimum scale of people.
What benefit we are giving to these 37 contractual classes? The petitioners are 200 in numbers, I think so, 200.
204.
Are they contractual classes?
Lordship, my lord, as per the, my lord, that annex of page 100.
In your affidavit, come to your affidavit.
113, lord. By way of agreement, lordship. They
You
have
had given them fixed pay,
lordship,
only of 11,000.
lordship.
Now, initially those who pursuant to the judgment of the single judge.
Lordship.
Have you regularized someone?
Lordship, as per the seniority, what I have stated in my affidavit.
That's true. How many?
My lord, how many the exact numbers I don't have. My lord, they have been regularized, and some of them are already been retired, and some are already been expired.
Okay.
Most of them are.
Then
After, my lord, the 2000, since 2011, it was, my lord, that they made an agreement for a contractual labor. In person, lordship, I have stated in my affidavit, lordship. Paragraph 6, lordship.
yes, kindly read.
Sorry, lordship, paragraph 8. That with regards to the statement made in paragraph 16 of the writ petition, deponent begs to state that the deponent has submitted a proposal for regularization service of the temporary grade 4 field staff and provide the letter number so and so dated 4/6/2011. Thereafter, another proposal for engagement of Khalasi and other grade 4 field staffs for 12 months in pursuant to the DRSE recommendation has been sent to the Gov via letter number so and so dated 26/4 April 2012, where it is requested for Gov approval for earlier proposal. However, as per the DRSE recommendations in its 9th report, under point number 3.6 and 3.7, the engagement of the Khalasi was made for the whole year, that is 12 months, with effect from 1/3/2013. White Gov letter number so and so dated 14/5/2013 on the contractual basis on the fixed remuneration. Accordingly, as per the Gov direction, the field staff signs the deed of agreement with the DLR of Assam and were engaged on a contractual basis on a fixed remuneration. Therefore, the subject from the receipt of the Gov approval, the service of the field Khalasi has been entertaining in its directorate for field operation continuously for the whole year, 12 months with effect from 1/3/2032 till that, as per a deed of agreement in view of the needs to complete the survey work.
Come to the second affidavit that you have filed.
Lordship, in a paragraph 5, Lordship, my kindly read it. That the deponent beg to state that as per the available record, out of the 204 numbers of petitioners, 37 petitioners Khalasi are doing their service on contractual agreement, and they said agreement were still in existence. Further, the deponent respectfully said that the total 168 Khalasi have been extended their benefit of minimum pay scale in pursuant to the letter dated so and so dated 6/5/2019, and in pursuant to the Gov letter dated letter number so and so dated 21/12/2019. Among these 168 Khalasi, the petitioner were also included, except the aforesaid 37 contractual employees.
Now, probably by this time that period is already over, because normally it was up to March.
Lordship. And time to time it has been, my lord, that agreement has
Whether
been
their
renewed.
services have been extended further by this agreement, or now you are paying them in terms of the decision of the division bench offenders.
Lord.
What is 37? What are you doing now? You're paying them in terms of the
Contractual, my lord, that those who are the contractual, Lordship, my lord, this is my lord, the contractual is 1 year. So after 1 year, if you want to, my lord, work in the department, they can my lord, sign in the agreement, Lordship.
Now, with regard to the other 168 petitioners,
Lordship.
right? 167 or 168?
168, Lordship.
37, 168, 205. How many are there?
204. You see, it should be, my lord, 10.
It should be 167, or it should be 38. Something is there.
Might have something.
But the list contains 37.
The list of 37 is otherwise correct.
Only 21, I think so. They are getting less salary, not in terms of the decision of the.
Malad, that
Vendors.
contractual agreement, Lordship, Malad, kindly see the page 113, Lordship.
That's in 2014.
2014.
What are they
14,
receiving
Lordship.
now? In the year 2023, when you have filed this affidavit,
Lordship.
how much they were receiving? How much you are paying to them? This is as per 2014. That is why I want to
15.
know the date on which you have filed your affidavit.
Lordship. Malad, that
So
is.
handy.
Lordship.
Do not have those instructions. What will happen? You have filed the affidavit without telling how much you are paying them. This affidavit was filed on 30th of January 2023.
Lordship, Malad, that this affidavit is filed in percent to the Malad or court's order.
What was the amount you are paying? You can understand that 37 are contractual. How much you are paying? That is a contractual of 2014. Why this half-made affidavits you are filing? Mr. Porpudari, can you tell us how many of you are paying the minimum of wages and how many are fixed salary? Do you have any instruction in that regard?
So perhaps, my lord, we have to take the data from the revenue department. Because, my lord, after Upendas, my lord, the finance department had undertaken a one-time exercise. And thereafter, my lord, all proposals were, my lord, invited from all the respective departments. And here is also a case, my lord, where the data were sent to the finance department regarding, my lord, for extending the benefit, my lord, of the Upendas decision. Now that has been done. Now, what would be the number of headcounts, my lord, to against which, my lord, that benefit has been extended? And perhaps again, we will have to take the assistance of the revenue department. Because it was a one-time exercise. The entire state of Assam, my lord, not only the revenue department, there are other departments.
Yes, now tell us. See, basically, the prayer that we have made, whether it can be considered at this stage only. Come to your prayer. Prayer number 2 is not there. Somehow 2 is dropped. So after 1, you have been 3, 4. So 4, we cannot consider. Division bench has taken care of that. Now, with regard to 1 and 2, tell us what.
Our submission is that, Lordship, from our Lordship, my submission is that from our initial date of joining, Lordship, we are all along being granted the regular scale of pay. Lordship. Subsequently,
Scale of pay or fixed pay?
no, Lordship, scale of pay.
Scale of pay of what?
Lordship, I will, if I may take your Lordship to the order.
Definitely, you might have receiving certain amount, but that has been taken care of by the Upendas, by the division bench. So that is why the finance department has passed the necessary notification. And if you come to the affidavit at page second affidavit, you will see that out of 204, 160 are receiving their fixed pay in terms of the decision of the Upenda. They will remain. Those remaining 33 or whatever. So 37, they are receiving in terms of their agreement because they have executed an agreement. Now the agreements that you have signed prior to filing of this petition in the year 2016 cannot be set aside.
Yes,
It has already over.
it is already over.
Now what is your
Lordship, now the
prayer number 4 cannot be considered because of the open division bench judgment. Right? Prayer number 1 and 2 cannot be considered because those periods are already over on the basis of an agreement. Those agreements executed by you and the employer.
Lordship, as regards the agreement, Lordship, as regards the agreement, Lordship, we are relying upon the judgment of Prajanand Ganguly, Lordship.
See, basically you have entered, nobody compelled you. There is no compulsion from the employer, it is you.
No, Lordship, there was unequal bargaining power, Lordship, because we did not have any power to bargain with the terms of our
That will not
contract.
be applicable here. Because by the time you were there, the reports are submitted before the division bench and the judgment of open desk came. Question of bargaining, you are not aware because the single bench judgment was against you. You cannot say that there was bargaining power with the employer before the open desk,
Lordship,
right? The single judge judgment was against you. It hasn't modified to the extent by giving a direction to the government in the case of Upender, right? So it is not that the bargaining power was with the employer. The judgment will not come here. Your cases are totally different. During that period, when that matter was pending, you have entered into an agreement securing your employment.
That, Lordship,
because the judgment is something else. You might have at that point of time decided it is better to be a contractual employee because for the whole year you will be benefited. You get something. You have entered, which you have not denied.
Initially, Lordship, my lord, that the sum of the petitioner was appointed only for some particular
Period, because not in
but
rainy
it is a
season, not in
seasonal work.
others,
Lordship.
it is seasonal work.
Lordship. When the season is come, my lord, they have been engaged in the work.
amount.
Thereafter, my lord, they have to.
Definitely, that is the indicated. Even by petitioners, they have indicated. The annexes are indicating that it is a seasonal work.
it is a seasonal work.
That is only these 37 petitioners entered into an agreement. So they are getting for the whole year, 12 months.
12 months.
The others who are seasonal,
Only 4 months or 5
they are
months.
getting it for a limited period of the year.
Lordship, as per my last instruction, Lordship, I have lost contact with you. As per my last instruction, Lordship, they are getting less than the minimum scale of pay.
That means that in that case you don't enter into an agreement. For others, for 168 as they have been done with you, because your names are included. You have been appointed prior to the FRBM Act came into force. You are in that list. So you are in that list. If you are in that list, submit a representative. That's all. But you have to show that your engagement was prior to FRBM came into your initial date of appointment. That stand will not be applicable. Judgments which are citing.
Our main submission was based on.
If you look, because that's the reason very clear. In fact, if you see, read page 107.
Mary. With reference to the government letter cited above, I have the honor to furnish the below the paragraph information as reserved by the government. The duty and function of the Director of Surveys Assam is to deal with the field survey operation all over the state of Assam relating to the village boundary, district boundary, interstate boundary surveys, and international boundary survey as per requirement of the concerned Deputy Commissioner and subdivisional officials and as per the order of the Government of Assam and Government of India as and when necessary. For this purpose, the Director of Surveys Assam requires to engage 247 numbers of grade 4 seasonal staff in every field season. Generally, field survey operation starts every year in the winter season commencing from October, November to the May, June of the next year. It is a fact that without the grade 4 seasonal staff, no field survey can be done by the Director of Surveys Assam. As and when government direction is received by the Director Survey Assam, he is to deploy survey parties to the concerned areas of Assam. In view of the above, the Director Surveys Assam considers the permanent retention of the 247 numbers of grade 4 seasonal staff in the interest of public service.
Next para.
Further, regarding non-survey season, it may be mentioned here that the Director of Surveys Assam is delegated power to grant departmental leave pay to the grade 4 menials during the non-survey season under Rule 136 of FRA.
So they will only get leave pay. They will not get the other salary. Right? That is why these 37 has entered into an agreement. They will get the salary for fixed pay for the entire year of 12 months. If you see the agreements for 12 months. That is why the judgment you are citing will not be applicable in the present. Now you are getting the minimum of wages only when you are engaged or for the entire year?
As on date, I do not have any instruction.
See, here when you have filed this, you did not mention anything regarding the, even after filing of the affidavit in opposition by the, there is no such reply from your side. Okay, we pass the order. Currently it's seasonal. That is why they are granted leave pay for that period, 6 months or 4 months or 3 months, whatever.
So therefore, my lord, that argument that they do not have the bargaining power.
No, that is why that will not, that particular decision will not come into applicable in the present case. And secondly, if these contextually, because we don't know, Mr. Hendrick failed to place, just tell us one thing, we are not passing the orders just now. If you can tell us by inform tomorrow morning, whether these 37 petitioners, whether they're still under a contractual employee or are they also given the benefit of the Upendas.
Lordship.
To tell us.
I will.
And at the same time, you also tell us one thing, whether these 37 were appointed prior to the FRBM came into force in 2005, because that's the date, crucial date. Their engagement have to be prior to the FRBM.
By September 2005.
If they are engaged and thereafter they have entered
in our affidavit paragraph, my lord, that we have clearly stated, my lord,
not with regard to the 37.
Lordship, that is true, Lord. Not with regard to the 37. My lord, after 2011, my lord, the 37, the contextual agreement has been made, Lordship. Prior to that, my lord, there is no contextual agreement.
That is why they are getting the amount, whatever fixed for them.
Lordship.
And the remaining is seasonal, but there is a list, we do not know.
Lordship.
Please come to that annexer 141.
141, Lord.
You also tell us within this 141 whether those 37s are there or not.
But the 37 are there at 139, Lord. The contractual employees list is at 139, Lord.
No, they are contractual, but their engagements were prior to, they are included in those because they have been included, they have joined the contracts were signed sometimes in the year 2011.
12,
right? But initially their engagements were prior to 1/9/2005 or not.
Lordship. Probably not, Lordship, subsequently.
If they are subsequent, they will not come under. There's benefits are given only to those persons who have been engaged prior to 1/9/2005. We'll make it clear, if their engagements are prior to 19, regular engagement are to prior to 1/9/2005. If they approach the authority concerned to pay them the minimum wage scale pertain to your notification instead of the agreement. Otherwise,
They are under these circumstances, they are quantumly eligible, so they are getting money for a period.
but Mr. Hendrick, tell us by tomorrow one thing, whether the other 168 who are getting the minimum wages in terms of this notification are getting this benefit only for the period when they are engaged. The remaining period they are not engaged, only because they are seasonal workers. In that circumstances, whether they have been paid for the whole year, 12 months, or only time of duty they are engaged. The remaining period, what they are getting. Get us that information, because we will be writing the judgment only after you give this information.
Lordship.
You also give us that.
Obliged.
Yes.
Lordship, I'm appearing for item number 7, my lord. Lordship, my senior would like to argue this matter, my lord. This matter may come up for hearing, my lord.
Yes, Mr. Courtinier.
Item number 7, my lord, we have filed our affidavit, my lord.
No, that starts from in item number 6807 you have filed.
We have filed in 6807, we have filed, my lord. 5129, we have not filed.
Not yet. Why? Time was granted to you.
Yes, my lord. In fact, I have been told that today, Mr. Sharma, he is filing, my lord. On last occasion, he took time to file the affidavit, my lord. And today,
They submitted that it was sent for vetting.
yes, my lord. Today he is filing, my lord.
Sure.
Yes, my lord. I have been told, my lord.
7 affidavit has been filed.
Yes, madam.
Yes.
8.
8 also, my lord. Filed.
Mr. Courtinier, Learned Council, Standing Council, Department of School Education submitted that the affidavits of the respondent department is going to be filed with application number 5129-2017, 5254-2017, and 5864-2017 during the course of the day. In view of the above, place these matters for admission on (26th). In the meanwhile, petitioner shall file their replies if any on or before 22nd. Please take it.
Orders.
I'm told your lordship will be rising.
Because
Item 24 is
this
not.
4 days we are fully tied of interview.
That's
Lots
true.
of candidates.
Item 24 is for non-payment of pension. My lord. So may I have a fixed date? Otherwise it will be delayed further. They have filed their affidavit. Yes.
Yes, Mr. Roy, you are appearing? No. Who is appearing for Tezpur University?
Mr. K. Gogoi is appearing on behalf for CCC, my lord.
K. Gogoi.
Yes, my lord.
Gogoi is appearing.
But
On the last
date may
day.
be fixed, my lord.
So date, my lord.
'27.
57.
My lord. Pledge me on 26, my lord.
26 is the motion day, I think. Tuesday.
Otherwise, it will be motion day.
26 का fix है.
27 will be motion day.
Okay, on 26.
Let's see, item number 9, it is regarding disability pension, let's say. Date may be fixed, let's say. SS Roy appears.
May I pray for item number 26, my lord? That may fix the pension matter, my lord. In spite of sanction of the pension, I am not getting, my lord, released by the authority. Maybe on Monday, my lord, next one. 9. Next week is difficult. That's why I say. My lord. These 2 weeks little difficult.
Item number 9, let's say first week of October, let's say.
9th, we are fixing it on 26, along with this 27. But Saranya, your material will come up on 29th. My lord. High level.